Good afternoon, everyone. I think we've got everybody back in, so we will kick off. Hope you all had an interesting morning, enjoyed some lunch and a bit of a stretch of the leg, and it's eyes down for the second half. The format this afternoon, we've got 2 talks, and then we'll take a quick break, then 2 more talks, and then we'll wrap up, and hopefully you'll join us for a drink at the end of the session. For the most part, this afternoon's sessions are going to be on some common law / High Court litigation related topics, but it wouldn't have been right, would it, for us to talk about employment law for a day without talking about the Supreme Court's decision in For Women Scotland, although apparently ELA managed to do that last week. We thought that we would talk a little bit about that decision. And I'm speaking with Ben Gray. We've taken a refreshingly different approach. This is obviously a highly contentious, contested area which engenders extremely strong views. We thought we would talk about what the Supreme Court actually said and what the case is about. So that's going to be the thrust of what we're going to do. We're going to go through some of the background legal framework, through the reasoning of the decision, and then talk a little bit about developments since the decision and some directions of travel afterwards. But this is primarily, cannot stress enough, a session about what the law is rather than what it might be or ought be. Before we go any further, I just want us to bear in mind some terminology that's used by the Supreme Court, so therefore we're going to use that terminology too. I'm not going to go through those definitions. Sorry, forgive me, I forgot to turn my timer on, so Ben's now worried I'm going to be using the whole of this slot. Let's bear in mind, though, from this slide, 2 different concepts which are crucial to understanding the Supreme Court's decision and its scope. On the one hand, the concept of a gender recognition certificate under the Gender Recognition Act. On the other hand, being in possession of the protected characteristic of gender reassignment. Those 2 very different concepts and their different treatment under different legal instruments is vital to understanding the scope of the Supreme Court's decision. What's the case about? It's worth bearing in mind what the factual context is for the dispute in Women Scotland. I did a straw poll of various people who are up on the news and interested in legal affairs as to what the issue was in the case, and I had a variety of answers about prisons, toilets, changing rooms, all of them wrong, of course, because it wasn't about any of those things. The dispute in For Women Scotland derives from a Scottish Act of Parliament in 2018, which was a measure to promote representation of women on boards of public bodies. Before one gets to the knotty issues as to how to promote representation of women, one needed to answer the fundamental question, well, what is a woman? Whose interests are we promoting? And the Scottish Government had 2 goes at giving guidance on what they meant by woman in the particular 2018 Act. Both of them were subject to legal challenge in the Scottish courts. The second go is the guidance that the subject of the Supreme Court's decision. But it's interesting to think for a moment about first time out. The first guidance that the Scottish Government issued defined woman as including not only biological sex, but someone who had the protected characteristic of gender reassignment, i.e. a wider definition than someone in possession of a gender recognition certificate. That was challenged in the first judicial review and held to be unlawful as redefining a protected characteristic outside the competence of the Scottish legislative powers. So the Scottish Government issued second guidance, which narrowed the definition by saying that woman included biological sex or someone in possession of a gender recognition certificate. And that, they said, was within Scottish parliamentary legislative competence because it merely gave effect to the Gender Recognition Act. Were they right about that? Well, that's the subject of the case that we're dealing with. The issue, the central question on appeal, is on this slide, and we quote from paragraph 25 of the Supreme Court decision: whether references in the Equality Act to a person's sex and to woman and female, and for that matter to man or male, but we're concerned primarily with women in the context here, are to be interpreted in the light of Section 9 of the Gender Recognition Act 2004 as including persons who have an acquired gender through the possession of a GRC, a Gender Recognition Certificate. That was the question, and the only question, the Supreme Court had to answer. What therefore was not the question are two important things. First of all, whether woman or man or sex in the Equality Act included a trans person who didn't have a gender recognition certificate. Nobody was saying that such a person was included within those terms within the Equality Act, a point that a lot of commentators or critics of the decision may have lost sight of. Second, what was not in issue was whether the Equality Act 2010 was incompatible with a trans person's human rights under the Human Rights Act or the European Convention. A lot of talk about that now. Ben's going to touch on that later, but that was not something that anybody was asking the Supreme Court to decide in the case. So, now we know what the question is, let's take a run-up at the legislative and legal history as to where we get to the position where the Supreme Court is reaching its decision. And there's quite a bit of content on these slides. I'll take it relatively quickly because this is just the backstory, the flashback, if you like. Common law position reflected in some matrimonial cases, particularly Corbett back in 1970, relied on the idea that sex is biological and that sex is immutable. And say cases where the courts had refused to recognise marriages, for instance, between a biological male and a trans woman, were the position that one sees reflected in Corbett and in other cases. Back in 1975, when the sex discrimination was enacted and just talked about sex and men and women, it's fair to say nobody within Parliament turned their mind to the status of trans people. And it's not really until 1996 that we see a change in the mood of legislators about a need to focus on the question, following the case of P&S in 1996, which held that the Equal Treatment Directive, European measure, required legislation to cover gender reassignment discrimination. And that led to the 1999 regulations, seen at the bottom of this slide, which established a protected characteristic of gender reassignment, someone who is going through or has gone through, intends to go through a process of gender reassignment. And those regulations from 1999 we see reflected in what's now Section 7 of the Equality Act, which sets out the protected characteristic of gender reassignment defined on this slide. Worth noting, as an aside, that that definition of what the protected characteristic is different now, it's wider than it was in 1999. But nonetheless, the core idea is the same, that when we look at the Equality Act, there is a separate protected characteristic of gender reassignment that protects from discrimination as per other protected characteristics, those possessed of the protected characteristic of gender reassignment. Not long after the 99 regs, though, a decision of the European Court of Human Rights in Goodwin decided that the legislative scheme in the UK was in breach of Article 8 in particular, also Article 12, by failing to give any legal recognition to the acquired gender of a trans person. So, in other words, by failing to recognise things such as rights to change birth certificates, passports, rights to marry, the law didn't reflect the Article 8 right in the personal dignity of an individual to be recognised as a person of their acquired gender. There was an attempt in the House of Lords to address that through the courts. The House of Lords, in a matrimonial case called Bellinger, said, there's a quote on the screen, but they basically said, we're not doing that, Parliament will need to do it. So, and Parliament indeed did tackle the question in 2004 in the Gender Recognition Act, which gave rise to the concept of the Gender Recognition Certificate, which is what the For Women Scotland case is about, at least in part. The crucial provision for the purposes of the For Women Scotland case in the Gender Recognition Act is Section 9, which, broadly speaking, for purposes of this slide, we'll look at the language in a minute, provides that someone with a gender recognition certificate becomes the acquired gender or sex for all purposes. Subject to Section 9.3, terms and conditions apply. We'll look at that in a minute as to what the restriction is. And the scheme of the GRA, whilst we're here, because it's going to be relevant to what Ben's going to be telling you about in the reasoning of the court, a couple of points to bear in mind. One, the GRC itself gets kept on a confidential register. Two, it's a criminal offence for a person to disclose the fact that an application for a certificate's been made or information about the certificate, including an offence by employers to do so. And third, there are some exemptions under the scheme in relation, for instance, in relation to gender-affected sport. Let's bear in mind, in passing also, the recent decision from reported earlier this year in Castellucci points out that the worldview of the Gender Recognition Act is a binary one. We're still talking about people who are either men or women, albeit acquired status one way or the other, rather than any non-binary or fluid status. So I said a moment ago we were going to look at the terms and conditions that apply in relation to Section 9. Here it is on this slide. And the two relevant provisions we've put up here. 9.1 says that where a full gender recognition certificate is issued, the person's gender becomes for all purposes the acquired gender. Underlying rationale is if a man has a gender recognition certificate, biological man, gender recognition certificate says they're a woman, that person is a woman in their acquired gender for all purposes. But, and the question is, how big's the but in this situation? How big is the qualification? Section 9.3, subsection 1 is subject to provisions made by this Act, don't need to worry about that, or provisions made by any other enactment or any subordinate legislation. What the Supreme Court decides is the question, as the lower courts in Scotland had decided, is when one looks at the Equality Act 2010, and we read the word sex, we read the word woman or man, does that mean biologically sex? Or is it an extended definition that includes, in accordance with Section 9.1 of the 2004 Act, acquired sex? If one reads 9.1 on its own, for all purposes, would suggest when we read the Equality Act, we have to read woman to mean someone in a trans woman in possession of a GRC, what the Supreme Court called certificated sex. But what about 9.3? Let's remind ourselves, subject to any other enactment. If the Supreme Court say the Equality Act's use of sex means biological sex, then that's the meaning of another enactment that's at odds with the GRA. And the effect of Section 9.3 is that Section 9 gives way to the meaning that's required by the Equality Act. So that's the question. When we read the Equality Act, do we read it to mean acquired sex or only biological sex? Never an issue as to whether sex in the Equality Act means anything wider than someone who's possessed of certificated status. And the Supreme Court approached this as a general principle of statutory interpretation, some quite useful nuggets in terms of approach to apply more broadly outside of this specific context. And the two broad thematic points they make, there's pages of it, but we'll give you the short version. First of all, you've got to consider the context and purpose of the statute that you're interpreting. Second, It's important that language in a statute is interpreted in a clear and consistent manner. The Supreme Court drew on a number of earlier administrative law cases in the House of Lords and the Supreme Court and made really these two crucial points. First of all, citizens with the assistance of their advisers are intended to be able to understand parliamentary enactments so they can regulate their conduct accordingly. They should be able to rely upon what they read in an Act of Parliament. So they're effectively saying, if you read the Equality Act, it's important for citizens, by which the court means not lawyers, to understand what it means. Good luck with that. Second point, the best way of ensuring a coherent, stable and workable outcome, emphasise those words, Ben's going to be talking about them, coherent, stable, workable outcome, is to adopt an approach to the meaning of a statute that's constant and predictable. This will be achieved if the legislation is construed according to the ordinary meaning of the words used. So that's the court's approach. Ben's now going to look at the detail of what the court decided and what's happened subsequent to the decision. Thank you.
The court held that the Section 9.3 provisions of the Gender Recognition Act would override the Section 9.1 recognition, where the terms, context and purpose of the legislation show that it is disapplied because of a clear incompatibility or because its provisions are rendered incoherent or unworkable by the court's application of the rule in Section 9.1. And the court addressed these factors in turn. Gavin, can I have the slide?
Oh, sorry.
Thank you.
With me.
Starting then with context and purpose, the court held that there was no doubt that when the Sex Discrimination Act was passed in 1975, it was using the terms woman and sex to mean biological woman and biological sex. As Gavin has already said, there was at that time no legal recognition or protection for trans people, and the exceptions that existed in the SDA were all premised on sex being biological. In the court's view, neither the 1999 regulations nor the 2004 Act altered this position. The regulations created a new and distinct protected characteristic, but did not change the definitions of man and woman. And insofar as the explanatory notes to the Gender Recognition Act may have said otherwise, the court said that little to no weight should be attached to these because they had not conducted any detailed analysis of the interplay between those provisions and the Sex Discrimination Act. The Equality Act 2010, in turn, did not alter that position. It was an amending and a consolidating statute. It was created in the knowledge of the 2004 Act, but there was nothing to suggest that it sought to amend the definition of sex to something other than biological. Moving then to the wording of the legislation, the court started by the premise that the terms sex and woman are plain and unambiguous. Their ordinary meaning in day-to-day speech is biological. By contrast, a certificated definition would cut across the protected characteristic of sex incoherently. Some provisions, in the court's view, only make sense if sex has a biological meaning. And you can see just over here the definition of pregnancy discrimination, the words in bold. Pregnancy discrimination is expressly a protection applied to women. But if the definition of woman is certificated, then a trans man in possession of a gender recognition certificate would, on that reading, lose protection from pregnancy and maternity discrimination. Second, the court looked at the policy purpose of the provisions of the Equality Act. There are significant areas of discrimination law that are based on group disadvantage or need, which the court says arises from differences of biology or physiology or social expectations or structures affecting their group. We are, of course, all familiar with this idea in indirect discrimination, but it extends further. And the court considered a range of other provisions in which this principle, they say, holds. There are far too many to cover in this talk, but one example is of single-sex services. Schedule 3 of the Equality Act permits a single-sex service to be provided where it is proportionate and where various criteria are met. For example, that only one sex needs the service. In the court's view, that would not work with a certificated reading. because you could hold a gender recognition certificate with no underlying biological change. And so, on a certificated reading, someone with a cervix and in possession of a GRC would be legally a man. The service provider therefore could not say, as a matter of law, that only women needed a cervical screening service, and therefore it would be impossible for that provider to satisfy the single-sex criteria. Looking more widely, the court identified that there were other provisions, for example, the protected characteristic of sexual orientation, that the court said could not depend on whether or not a person was in possession of a certificate. The court further observed that the Equality Act's drafters extended protection to GRC holders through express words doing so. For example, parts of Section 9 extending protection in cases of marital exemptions to say these are cases involving sex, but then there are cases involving people holding a gender recognition certificate, and that was the means through which gender recognition certificates acquire protection in the Act rather than a change to the underlying definition of sex or woman. It therefore followed that at least some of the legislation had to have a biological definition of sex rather than a certificated one. And in the Court of Session below, the court agreed with that proposition and said that some of these provisions must be biological, but others can have a certificated reading. However, the Court of Session declined to identify which ones carried which meaning. And the Supreme Court was unsatisfied with that answer. It thought it cut against the ideas of certainty, consistency, and predictability. You've already seen in a previous slide the quotes from administrative law cases about the importance of everyone being able to rely on an Act of Parliament and for the words to carry the same clear and consistent meaning. But the Supreme Court went on to say that by its nature, a variable definition is neither clear, consistent, nor predictable, whereas potentially there is a clear way to identify when someone is of a particular biological sex. In the court's view, it cannot be for individuals and organisations to work out which definitions are biological and which are certificated without clear assistance from the words of the legislation itself. And this was going to create, in the court's view, difficulties for those charged with duties under the Act to identify the scope and content of their duties. To begin with, duties towards individuals, one could not, on a practical day-to-day basis, regulate legal rights or protections by reference to categories that can only be identified by knowing who possesses a confidential certificate, the disclosure of which may be a criminal offence. By contrast, biological sex may continue to be readily perceivable and may form the basis of unlawful discrimination, even after a GRC is obtained, meaning that even when in possession of a certificate, a duty may still be held to that person on the basis of their biological sex. In terms of the duties towards groups, a dual interpretation would make it unclear, in the court's view, when it is permissible to treat biological women as a distinct group whose interests need to be protected. Duty holders need to be able to anticipate the distinct needs of protected groups and regulate their conduct accordingly. For example, to avoid indirect discrimination, to engage in positive action, or to discharge the public sector equality duty. It is therefore essential that duty holders are clear on what groups are protected and why, because there needs to be a robust analysis of biological men or women as a group with a shared characteristic. The court held that it went further. Direct discrimination itself could be undermined because in some cases, like James and Eastleigh, the case where access to a swimming pool was dependent on retirement age, but the retirement age was different for men and women, required direct discrimination to be proved through an exact correspondence between the requirement and sex. A certificated reading would water down the ability to do that. So in the court's view, a certificated reading of sex would create complex, heterogeneous groupings rather than the distinct group of men or women with their shared biology, leading to shared disadvantage and discrimination faced by them as a distinct group. Rather, in the court's view, trans people face different disadvantages in society and their needs and the analysis of them must be addressed distinctly. And the court further held that this was unworkable because of the inequality of status it would create. As Gavin's already pointed out, This is not a case about trans people as a group. It is about trans people who hold a gender recognition certificate. That is a small minority of all trans people. There would be no obvious way for a duty holder to distinguish between which trans people hold a certificate and which do not. And yet, on the proposed reading of the law, the legal rights, duties, and protections would be different. The court therefore held that the guidance issued by the Scottish Government was unlawful, and that under the Equality Act 2010, sex in all contexts meant biological sex, and the possession of a gender recognition certificate did not change that. Now, it's fair to say there have been a few developments since the judgment has come out. There is ongoing debate about whether or not the decision was the right one. We obviously cannot get into that. As a matter of domestic law, the Supreme Court is the highest court in the land. Its statement of the law is authoritative. The Equality and Human Rights Commission has issued an interim update as of yesterday. It also issued a draft code of practice for services and public functions. I am not going to get into the details of that now because it could occupy an entire talk, but the key point to note is that there are already indications that organisations intend to challenge this guidance as unlawful. The areas of challenge, either to the Supreme Court decision or any guidance issued in consequence of it, seem to be focusing in on whether or not this interpretation is compatible with the European Convention on Human Rights and the decision in Goodwin. From a legal perspective, it seems unlikely that those challenges will succeed at the domestic level. Section 3 of the Human Rights Act only requires a convention-compliant reading of the legislation insofar as it is possible to do so. Regardless of which way the courts find in terms of whether this interpretation is compatible, it seems clear that the Supreme Court's view, given the reasoning, is that it is the only possible interpretation of the legislation, meaning that the outcome of any challenge would be, at most, a declaration of incompatibility. That approach is likely to be consistent with the court's previous decisions in both Bellinger and Castellucci that these are matters, in the court's view, for Parliament. And that seems to be the crux of the Supreme Court's decision. The Supreme Court's view appears to be that the question of how and when people with a protected characteristic of gender reassignment and or GRC should be treated in law as the opposite sex is a matter that requires consideration by Parliament, and that any attempt to do so by the Gender Recognition Act didn't have sufficient regard for how it would interact with equality and discrimination legislation more widely. It follows that there may then be pressure on Parliament and lawmakers to amend the Equality Act 2010 to provide an extended definition of sex for the purposes of some of its provisions. Whether or not that happens is, of course, a political question rather than a legal one, so I'm going to offer absolutely no predictions or insight on it. But what I can offer is some implications for us as professional advisors. The first thing to note is that the court was at pains to emphasise the existing protections for trans people, and indeed the draft code of practice out for consultation as of yesterday does the same. As we know, the definitions of direct discrimination and harassment are widely drawn, and you do not need to have the protected characteristic yourself in order to bring a claim under it. If a trans person is perceived to be a woman or is associated with women and discriminated against or harassed on that basis, then they can bring a claim for sex discrimination. Likewise, the recent amendment of Section 19A of the Equality Act means that if you experience the disadvantage that is common to a protected group that you don't belong to, you can still bring a claim for indirect discrimination. So many of the same protections still exist. It would be incumbent on advisors to think carefully about how to plead those claims, considering whether it is going to be on the basis of association or perception. It is probably sensible also to plead discrimination on the basis of gender reassignment as a further or alternative claim. And gender reassignment, of course, remains a protected characteristic. The decision in Forstater and CGD Europe at paragraph 90 remains good law. Misgendering people gratuitously is going to remain an act of gender reassignment-based harassment. In terms of wider legislation, you've really got two kinds, mandatory ones and permissive ones. The mandatory provision is, for example, the workplace health, safety and welfare regulations, requiring employers to provide either single-sex toilets or individual lockable rooms. Although this was not expressly addressed in the Supreme Court's judgment, it is likely that this is going to be viewed as a reference to biological sex, because much of the Supreme Court's reasoning is about the justification for separate facilities and can therefore be read across quite easily. The likely area of challenge will be if an employer or service provider only provides single-sex toilets, and that might be challenged as indirectly discriminatory on the basis of gender reassignment. It follows that any employer will have to consider the needs of its workforce and proportionality with care. The greater area for challenge is where there are what I've called permissive exemptions, legislation that says that you can provide separate services or facilities on the basis of sex or another protected characteristic. And the way these exemptions normally work is essentially an extended justification defence, like in an indirect discrimination claim. You have to fulfil certain statutory criteria, and you have to show that the treatment is proportionate. And the challenges are therefore likely to be on, first of all, whether the ground is made out, and second, whether or not it is proportionate. And again, that will require employers to take careful stock of their workforce, its needs, and what proportionality requires. Equal pay claims, of course, require actual comparators, and that comparator is going to have to be of the opposite biological sex. And then, in terms of wider litigation, historically, the definition of gender reassignment has been under-litigated. It is very wide. It does not require that you be under medical supervision. It starts when you are proposing to undergo a change, and it is not just a change to the physiological attributes of sex, it can be a change to the other attributes of sex. It may be that there are further challenges brought that seek to identify where the boundaries of this protected characteristic are, and it seems likely that there will be a greater willingness to bring claims arguing indirect discrimination on the basis of gender reassignment. Thank you very much.
Thanks very much, everyone, and thanks very much, Ben. I'm going to we'll have a quick swap over, ask James Bitford-Smith and Bianca Barmelli to come up to the table.